Hello and welcome to another edition of Lunch and Learn with Legacy Washington. Legacy is a history program housed in the office of Secretary of State Kim Wyman, along with our colleagues in the State Archives and Library. I'm Bob Young, a historian with Legacy, and I'm really looking forward to today's conversation with Dr. Helen Knowles, a professor and author of a new book about a little-known Washington woman who played a historic role in the fight for minimum wage. Welcome, Helen. Thanks for joining us.
It's very much my pleasure. Thank you for organizing this.
Oh, it's great to see you. And I should note, Helen was a great help to us in our own research about Elsie. Her book, we wrote a magazine-length piece for our book, Ahead of the Curve, about trailblazing Washington women. Helen has written a book called Making Minimum Wage, Elsie Parrish versus the West Coast Hotel Company. And it tells, its central character is Elsie Parrish. And I'm certain that Helen is the world's foremost authority on Elsie Parrish and her fight for the minimum wage. So without further ado, Helen, why is Elsie's case so important to scholars and just ordinary Americans?
Great question. I think every scholar or teacher of American constitutional law or American legal history has heard of, and if they're a teacher, they probably teach West Coast Hotel versus Parish, the lawsuit that Elsie was involved in. It's genuinely one of the US Supreme Court's landmark decisions. And as one scholar has quite correctly said, it's the decision that launched 1,000 law journal articles. It's cited left, right, and center. But far fewer ordinary folks, I think, will have heard of the case, and I think that's totally understandable. I bet, however, that many of them have heard of President Franklin Roosevelt's effort in 1937 to increase the size of the US Supreme Court, what we know today as to pack the US Supreme Court. And for reasons that we can get into later, the Parish case has always been associated with that effort to pack the court. Basically because of the timeline, the two happened so close together. But again, for reasons that we can talk about later, it's completely wrong to link those two. And what it does is to undermine the stories of this case. And so little is known about the actual story that, as one prominent law professor once told me at an academic conference, everybody knows about the case, but I thought that Elsie Parrish sued the West Coast Hotel. It's so unknown in terms of the story of the case that people don't even realize that she wasn't suing the West Coast Hotel. She was suing the West Coast Hotel Company, and the hotel she worked at was not the West Coast Hotel, it was the Cascadian Hotel. To the extent that in some law journal articles, even today, hopefully this will change after my book is published, even today, law professors will tell you in these articles that Elsie Parrish worked at the West Coast Hotel, which is flat out wrong. And so really what I try to do in the book is to uncover the stories behind this case and to say that its importance is it fundamentally changed the labor law of the land, and it fundamentally changed the bargaining position in terms of the law of workers, especially women workers. And I think I can give you a quotation which sort of really summarizes what the sort of driving spirit of the book. In 1936, Eleanor Morehouse Herrick, who was the head of the New York division of the National Labor Relations Board, said the following about minimum wage laws. She said, they don't involve an academic question or even a legal question. They involve a human problem. And I think really that is what animates this book.
Mm. And what made you, I want to note that you really attempt to go beyond just the names on the lawsuits and depict people, Elsie and others, as real three-dimensional characters, human beings, which so often is omitted in the legal analysis of these cases. So what got you so interested? How did you get so interested in Elsie Parrish?
Well, like every other professor of constitutional liberties, I'd heard of the case. And I was thinking about this last night. I cannot actually remember how I thought about the case prior to starting to write this book. I can't remember what West Coast Hotel versus Parish meant to me before I started to uncover Elsie's story. And that happened, that sort of uncovering process started to happen about 11 years ago when I was teaching at Whitman College. I was there as a 2-year appointment as a visiting professor of politics, and I was assigned to teach their law and politics courses. And one of the things I always like to do, particularly when I teach civil liberties, is to encourage the students to go beyond the law. Law is about human dramas. And I can't emphasize that enough, the humanity of the law. And if you just read the cases, the opinions of the justices in the books, you often find out nothing about the people involved. So I assigned all of the students in the course to write papers trying to uncover some of those stories for their case of choice. 2 of the students wrote about West Coast Hotel versus Parish. And it kind of piqued my interest. And I kind of realized that I would be living for 2 years just about 180 miles away from where this case took place. And me being me, I immediately wanted to start doing some research in Wenatchee. It's kind of, okay, 180-mile road trip. Let's go to the Wenatchee Library. And the rest, as they say, is history.
I have to ask Helen, since I don't know this part of the story though, why Whitman? What brought you to Whitman and Washington State?
A matter of personal family issues, in all honesty. I was in a tenure track position at the State University of New York at Oswego, which I went back to, very long story, and suffered a major family tragedy at that point in time. And it was really necessary for me to just sort of take a step back from my career and move out to the Pacific Northwest for family reasons for a couple of years. And very luckily, completely by fortune, Whitman were looking for a 2-year position, visiting professor at the time. And that got me a whole lot closer to family members. So that's why I ended up at Whitman for 2 years.
Oh, well, that's to our benefit, I suppose, and history's benefit.
Yes.
So Elsie, again, I not to belabor this point, but so often we don't know these people involved in historic landmark lawsuits. Brown versus Board of Education, as your book points out. Who really knows Olivia Brown? This being, we just recently commemorated the Japanese American Day of Remembrance about World War II incarceration. I mean, who really knows who Fred Korematsu is in that landmark U.S. Supreme Court case? So you really do a great, and by the way, I think Elsie was a lot harder, her story to unearth than perhaps people like Olivia Brown and Fred Korematsu. One reason being she was just a working class person through and through. And why don't you tell us a little bit about her life and the hardships that this woman faced from her various early age?
I think the best way of answering this question is to tell you what I do on the very first day in class when I teach this case. I look out at the students and I ask my female students, how many of you are 20? And invariably a few hands will go up in the room. And I've got everybody's attention. And I say to the women in the room, for those of you that are 20, if you were Elsie Parrish, by now you would have been married for 5 years and had 6 children.
Wow.
And that's when, if I didn't have their attention before that, I certainly have their attention then. Now, admittedly, getting married at a very young age and having a large number of children at a very young age was far more common then than it is today. But nevertheless, those statistics give you an idea, sort of just scratch the surface of some of the hardships that Elsie faced. She was born in Kansas in 1899, rural Kansas, lost her father in an absolutely horrific farming accident. She was very young age. She was maybe 1 year old when her father died. And then her mother raised her and a huge number of siblings on her own for a few years and then remarried. The best I can tell, Elsie met her future first husband, Roy Lee. She was probably a teenager when the two met because he was from fairly close by. And then somewhere, I don't know where, but somewhere between Kansas and Montana in 1914, 1915, again, I haven't been able to uncover the actual records, the pair got married and Elsie had her first child shortly thereafter. And from that point onwards, from about 1915 to 1930, her and her first husband lived with her in-laws. As if life wasn't difficult enough for her, she had to live with a gaggle of kids, her alcoholic husband, and his parents in rural Montana.
Wow. So they make their way from Montana to Washington State, first to the Moses Lake area.
Mm-hmm.
And at some point, I'm trying to remember, Elsie leaves her husband, divorces her husband.
Yes, I mean, this gives you an idea of how much bravery and courage Elsie had, because it was her of this on good family authority. It was her that initiated the divorce. 1930, 1931, shortly after the pair moved to Washington, I think by that time, Elsie had just had it with half her life tied to an alcoholic spouse. And so she divorces Roy Lee and ends up shortly thereafter in Wenatchee. And that's where the next part of her story takes place.
Tell us where she went to work, and which is obviously an important part of the story.
Yep, well, she didn't go to work at the West Coast Hotel. She went to work at the Cascadian Hotel, which to this day remains the tallest building in Wenatchee. And it was opened in August 1929. Not a great time to be opening a building, as people clearly found out a couple of months later when the stock market crashed. She went to work at the Cascadian as a chambermaid in 1933, initially part-time, and then was taken on full-time and worked there until the middle of May 1935 when she was fired.
And for those who may not be familiar with the term chambermaid, Elsie was someone who cleaned the rooms of the guests, changed the sheets, cleaned the toilets and such. And the Cascadian was then just a splendid considered a splendid edifice. And I'm just going to digress here quickly because I find this really interesting. So Helen did so much research into the Cascadian that she ended up spinning off a book, kind of a coffee table book with a Wenatchee historian, Berlin Spargo, just about the Cascadian. Um, and and tell us about the expertise you gained and why the book was spun off, and what did you learn about the value of holding on to all your research? There might be something in here for other historians.
Yeah, this was a really fun spin-off project. If you told me that I'd be getting 2 books out of one set of research when I started this, I'd have said no way. So when I submitted several draft chapters of the Parish book to the publisher, they sent them out for review as peer review presses too. They sent them out to a couple of excellent external reviewers who both came back with the same comment that essentially told me what I already knew. But having done all this research, I needed somebody else to tell me what I already knew, which was, although a nauseatingly detailed description of the hotel, right down to which company manufactured the carpets and what color the walls were, was really interesting. Kind of detracted from the story about the lawsuits. So I was browsing in a bookstore one day, and I saw, as many people will have seen, a lovely display of these historical books published by Arcadia Press. And I thought, there's a book to be written. And I contacted the press. I sent them the same draft chapter that I had sent to the publisher for the Parish book. And they said, as long as you find a local co-author, because that's our requirement, then we will publish it. And again, not to belabor the phrase, but the rest is history.
So Elsie, thank you for that, Helen. And I just was able to glimpse some of Helen's expertise. For instance, I think you became expert in air conditioning in the 1930s,
Yes.
if I'm not wrong.
Yes.
One of the features of the Cascadian. And by the way, it opened with much fanfare, and Helen's book has got some great stuff about that. It's got some stuff about celebrities who stayed there, on and on. But so back to Elsie, she's a chambermaid, and she realizes she is not being paid what she's supposed to be paid. What is the backstory there? I mean, in effect, Washington had a minimum wage. It was one of the first states to have one. Take it away, Helen.
Well, let's start with why Elsie was fired. Now, this might sound strange to people watching this, but I have to emphasize that I cannot tell you until the book is published how I know what I'm about to say. I can't reveal the source until the book is published, but I can tell you that I do know for absolute certainty that Elsie was fired in May of 1935 because she knew that she was not being paid the legally mandated minimum wage that Washington State had in place. And as you might imagine, a major employer of women workers, because all the women, which the chambermaids were women, this major employer of women workers in Wenatchee was not about to retain the services of somebody who was going to tell her female colleagues, oh, you're all being underpaid as well, because the hotel could see a flurry of lawsuits coming.
So Elsie's like Norma Ray or something. She's beginning to, well, the concern is she's going to agitate other workers, right?
Yep.
Now, so Washington State had established a minimum wage back in 1913. It was the fourth state to do so. And it did it just after women in Washington were granted the right to vote. They were granted in 1910, 10 years before the 19th Amendment gave all American women, I shouldn't say all American women, gave many American women that right. So, one note, well, what was she supposed to be paid, and what was she paid?
Oh, now there you get me off the top of my
Oh,
head.
that's all right. I can remember what she
I
was
know she was
supposed to.
paid. Yeah, she was paid $14.50 a week, I think, but
That's
don't
what she
quote.
was. Well, that was what she was supposed to be paid.
Okay.
For $14.50 for a 48-hour week. And one reason this sticks in my mind is because somebody had once quizzed me about that figure, because they had tried to puzzle it out in an hourly wage basis. And I had to explain to them, no, the Washington law established this commission, and then the commission would set wages by a 48-hour week for different occupations. So one class of worker might have a slightly different minimum wage than another. So it was $14.50 for a 48-hour week, and Elsie was being paid less than that, and she knew it. And even though she's not an educated woman, even though she's not a woman of means, even though she's not represented by a labor union, she decides, I've had enough of this. And
Yes.
she's a tough enough lady, and one with enough gumption to go looking for a lawyer. And fortunately, she found who?
She found C.B. Connor, Charles Burnham Connor, and it's not as though he was the only attorney in Wenatchee at the time. However, I like to think of him probably as the only attorney with the similar amount of bravado and gumption willing to take Elsie's case, because for reasons we can discuss, pretty much every lawyer in town would have known or would have assumed that this was a losing case right from the get-go. And so it was a losing case. She was suing an incredibly important employer in town. Why take on her case? And if you add into that the fact that she couldn't afford to pay a lawyer would be doing this pro bono. There aren't very many lawyers who, given those factors, are going to take her case. And the more I found out about C.B. Connor and the more I interviewed members of his family, the more I liked him. And the more I realized he was the perfect lawyer for Elsie. And he represented Elsie and Ernie in other legal matters. This was not the only case that he was involved in as their lawyer.
And you just mentioned Ernie, who was Elsie's second husband. She married in Wenatchee. By the way, as Helen informed me, and you can find it. I think it's in it's across the street at the Temple of Justice in the Washington Supreme Court Law Library. You could see in the case the hours and days she worked. And anyway, my point being, she actually worked on the day she got married to Ernie, correct?
Yes, she did.
Just remarkable.
July 28th, 1934. I think she works a full day's work and then gets married at 8 o'clock that evening.
Oh, wow. So CB is not some young lawyer who's just hung a shingle and looking for cases, any case. He's an established lawyer in downtown Wenatchee. And even then, Wenatchee was so ambitious to proclaim itself the Apple capital of the world. And so CB decides to take her case, knowing he's going up against one of the biggest employers in Wenatchee. And as you mentioned, Helen, why don't you tell us more about why the hotel owners, or CB for that matter, knew this was a long shot case, that So take us back a little bit into the legal history here.
So, as you mentioned earlier, Washington State was one of the earliest states to enact a minimum wage law for women. The first state was Massachusetts. That was in 1912. But in all honesty, Massachusetts remains a kind of footnote in the minimum wage for women law history, because the law was essentially unenforceable and had all sorts of other problems associated with it. The laws enacted in 1913, by contrast, including Washington State's, were very much more substantive. Washington's law was enacted sort of on the wings of this progressive spirit, which was very, very strong in the Pacific Northwest. It had the support of Governor Lister at the time. You know, he cautioned legislators about not going too fast with policy issues, but he didn't classify minimum wage laws as something that the legislature should slow down on. So the law was enacted in March of 1913, and a number of other states followed suit. But it was quite clear, given US Supreme Court law of the land, that there would be a challenge to these laws sooner rather than later. And this goes back to a 1905 decision by the US Supreme Court, which I always have fun teaching, not only because it's a dubious landmark in the history of the US Supreme Court, but also because I live about 8 miles from where the case originated. Joseph Lochner ran a sort of not a home bakery, but a small bakery bake shop in Utica in central upstate New York. And in 1897, New York State had enacted a law that said that bakeries had to limit the number of hours that their employees worked, basically for health and safety reasons. You know, today we think of big sterile warehouses where all sorts of health and safety codes are being met. That's what we think of with bakeries. Not so much with a sort of a basement bakery like was being operated by Joseph Lochner. All sorts of health and safety issues, including lung diseases that bakers were contracting. And New York said, maximum working hours is what we need. We need to limit the working hours of bakers to preserve the health and safety of them and their customers. Joseph Lochner said, not so fast. I want to employ my financial reasons. I want to have the freedom to employ my workers for as many hours as they want to work. They should be contractually free if they want to work for 23 hours a day. They should be contractually free to do that. And in 1905, in Lochner versus New York, the US Supreme Court, in a very fractured, very controversial decision, said, you know what? When we see that word liberty in the Constitution, we interpret that as involving or as including liberty of contract. So the Constitution therefore protects your contractual liberty to work as many hours as you want. What does that have to do with minimum wages? Well, a lot of people thought that if there was a contractual liberty that protected you from the government saying how long you can work, it also protected you from the government saying how much you must be paid. And not to get into the legal weeds too much, by the late 1910s, reformers very clearly realized that they were living on borrowed time in terms of the constitutionality of minimum wage laws. And then in 1923, the US Supreme Court comes along and does what basically everybody was expecting them to do, which is to rule unconstitutional a District of Columbia law providing for minimum wage workers. Minimum wages for women workers. And that was considered to be a very strong, solid piece of the law of the land. And when I mentioned earlier that every lawyer knew that Elsie's case was likely to be a losing case, it was because of that decision in Adkins versus Children's Hospital.
And quickly, scholars, law students, they know the bakery case as beginning what is called the Lochner Era, because there was this narrow majority of the court that held on to this idea, this laissez-faire economics idea that there shouldn't be state government or government regulation of work conditions like hours and wages. So we had this period of time where the court was kind of just firm in that position, hence the Lochner Era. Then, so that's why the hotel owners and their lawyers thought that they would prevail against Elsie's lawsuit. So nevertheless, Elsie and CB filed their case in Chelan County Court. The judge there basically takes the position of the United States Supreme Court, if I'm right, Helen, is that correct?
Yep.
And rules in favor of the hotel. Yet Elsie and CB persist. She persisted, and they bring it to the Washington State Supreme Court. And what was the kind of surprise there? I guess it wasn't a surprise, but what happened?
Well, just sort of before I directly answer that question, just to sort of backtrack a little bit, this idea of the Lochner Era persists today in legal scholarship. What I try to do, one of the things I try to do in the book is to sort of follow the lead of a couple of scholars who've really influenced my work to show that that Lochner Era was not as set in stone as everybody thought it was. And I was able to show that the Lochner Era wasn't really as much of a sure thing, wasn't really a Lochner Era as such, because of what C.B. Connor did in his legal briefs. He drew attention at both the Washington Supreme Court level and at the US Supreme Court level to a couple of decisions from the early 1930s, which really undermined the strength of the Lochner decision, but hadn't really been clearly identified as doing so. So he latched onto these other precedents, and Supreme Court did and what the US Supreme Court did in Elsie's case. And as you say, everybody was expecting, I think even if we could bring CB back, I'm sure he would say he was even expecting to lose at the Washington Supreme Court. But at the beginning of April, he didn't. He and Elsie were victorious. And Chief Justice William Millard wrote the opinion for the case. And it's a really interesting opinion upholding the Washington minimum wage law, essentially saying the previous decisions we've made as a court are more important than the contrary opinions that the US Supreme Court made, which totally throws the idea of federalism out of the window, the idea that federal law should be supreme. But from what I found out about Chief Justice Millard, he was very much driven by the importance of basic principles of justice, which he saw in the state Supreme Court decisions and not in the US Supreme Court decisions. And a sort of really interesting little bit of research I came across here relating to that decision came from one of the grandchildren of Fred Crollard, who was the lawyer for the West Coast Hotel Company. And, you know, people might think that I would want to demonize Fred Crollard for defending the hotel, which didn't want to pay these downtrodden women their minimum wages. He was just doing his job representing the hotel. He wrote a letter to his son right after the decision in the Washington Supreme Court case. He couldn't have been more surprised if he had tried. He was just totally shocked. He thought the court would just say, "See, Adkins, our hands are tied." He just couldn't believe what he was reading, that he had lost.
Mm-hmm. And then I think, the turns from here get really interesting because this is the Washington Supreme Court makes its decision in April of 1936. And by the way, I should have stressed that this is all unfolding against the deprivations of the Depression. And Wenatchee, for instance, has a 24% unemployment rate. So these are tough times. The country has really felt by this point the hardships of depression, if they hadn't already. So quickly, the U.S. Supreme Court decides to take yet another minimum wage case in the summer of 36. If I've got this right, reformers in New York said, wait, we think we've got a case that is kind of bulletproof, that is going to somehow beat the liberty to contract. I don't know the details, but we need not go over them. So anyway, their case involved, it sounded like a good case for the reformers. Their case involved a laundry manager, Joe Topaldo, who would pay his laundresses minimum wage, New York's minimum wage, but then force them to kick back 1/3 of their wages. So they went after him. The case makes its way to the Supreme Court, where once again, reformers are disappointed because the Supreme Court, in another 5-4 decision, upholds the liberty to contract. Now, in a couple of months, they decide to take on the appeal of the hotel company. So Washington Supreme Court has ruled for Elsie against the hotel company. The hotel company appeals to the U.S. Supreme Court, they had to be feeling pretty darn confident. And it's interesting to me that the Supreme Court even decides to take up the case, having just ruled on it months before. But much has been much turbulence has been roiling the country at this point. And your research, I think, is just excellent on this, Helen. So the Supreme Court, once again, rules in favor of the employer, but the public reaction this time seems different. Tell us about that.
In short, overwhelmingly negative. Overwhelmingly negative. There was one very prominent scholar, I think a number of decades ago, did a study of newspaper editorials at the time and could find very few in defense of what the court had done. And we live in an era today where bipartisanship just seems never to exist. Well, one of the interesting things about the reaction to Topaldo is this was a presidential election year, and both the Republican and Democratic parties really made significant efforts to introduce into their presidential election platforms of that year some kind of language denouncing what the court had done. You could find very few defenders of what the court had done in Topaldo.
I thought that was really interesting. That made it into both parties' conventions. Right. So then the Supreme Court, a little foreshadowing here, they decide to hear the arguments in West Coast Hotel versus Parrish at the end of 1936. Excuse me. In this case, C.B. Connor does not make the long trip back to Washington, D.C. Instead, an attorney for the Washington State Attorney General's office, who's already in D.C., makes the argument before the Supremes. So now we move into 1937, and FDR kind of drops big bomb. And what is that, Helen?
Yes, this is where the traditional story of West Coast Hotel versus Parish goes so wrong, or becomes misleading, I should say, and certainly this is where the stories get obscured. On February 5th, 1937, FDR announces his plan to pack the Court of Justices. This would be a law.
I'm sorry, Helen, why does he do that? I skipped a part of the story.
So time after time, FDR is coming up against a conservative Supreme Court that is striking down his New Deal reforms. But they consistently do it by a 5-4 majority. So FDR says, you know what? Let me just put a bunch more justices on the court to give me a foolproof liberal majority. Now, he'd been hatching this plan it was a very, very closely guarded secret. He'd been hatching this plan for a couple of months. He tries to sell it to the American public and defends the plan as helping agencies with their workload. That it's sort of efficiency of the court's workload. They need some help. Let's give them some additional members. That was about as transparent as I'm making it seem. Everybody knew that this was FDR trying to pack the court to give him a liberal majority. On March 21st, the US Supreme Court still hasn't decided Elsie's case. March 21st, 1937, Chief Justice Hughes sends a letter to the Senate Judiciary Committee, basically blasting open FDR's efficiency concerns and showing them for what they were, which was totally baseless. And then that's read to the committee, I think, on March 22nd. So that becomes public. Exactly a week later, the court announces the decision in West Coast Hotel versus Parish, where it's now a 5-4 decision the other way to uphold the minimum wage law. And so everybody goes, aha, surely there has been this great switch by one justice. The justice in question was Justice Owen Roberts, and everybody at the time blamed him for being what one journalist came up with, a wonderful quip, a switch in time that saves 9. A switch in voting in minimum wage laws to uphold the New Deal agenda and preserve the size of the court. What people didn't realize, well, I have to be careful what I say here because I don't want to give away something important in the book, because I want people to find out this important in the book. But a very small handful of people did know at the time that that was not true. But generally speaking, it wasn't until much later that historians uncovered correspondence which clearly showed that the justices voted on the Parish case in December of 1936, but simply waited until March to announce the decision because Justice Stone was hospitalized at the time. The vote was 4-4, but everybody knew that Justice Stone was going to uphold the Washington state law, so they just waited for him to come back. But in the meantime, FDR had dropped this bombshell, so by the time Parish is decided at the end of March, everybody assumed incorrectly that they were pushed to change their minds because of the court packing plan.
Right, and as Helen points out, this myth of the switch in time that saved 9 just lived on. It was so glib and easy to grasp onto, but historians have found that, in fact, that was not the case. I want to quickly, Helen, digress to ask you about the fact that the minimum wage for women was not popular with all women. For instance, who were the leading women opponents of that?
The leading women opponents were a group of feminists, primarily members of the National Woman's Party, and they opposed minimum wage laws for two basic reasons. First of all, they thought it intruded upon the liberty of the woman. The woman should be free to bring herself, sort of pull herself up by her own bootstraps. She didn't need governmental interference to get these kind of wages that she deserved. And then secondly, they were very much opposed to minimum wage laws for women only, because not only would such laws intrude on women's liberty, it would sort of, by having a minimum wage law for women only, it would suggest that women were inherently unequal and needed this special treatment. And one of the wonderful things I found, and I discussed this in more detail in the book, is some of the correspondence that members of the National Woman's Party wrote to the dissenting justices in Parish, lavishing praise on them and saying that the court had just destroyed the liberty of women and how wonderful you were to be rejecting that decision.
And these are some of the nuances that I appreciate so much in your book, because the easy story is to say, oh, this was great for women. The conservative justices were grouchy old men, and if not worse. But as you point out, one of the justices in dissent was Justice Sutherland, and he was hardly some monolithic misogynist. As a United States senator, he was a sponsor of the 19th Amendment 5 years before it passed, and the National Women's Party knew this, so they did, as you say, lavish praise on him for his thoughtful defense. I mean, it was about more than just liberty to contract. I think it's fair to say in his case. So the court makes its decision on March 29th, the Monday after Easter, and it has a sweeping impact. So tell us what happens after that.
Yeah, I think one of the things I really try to emphasize in the sort of closing chapters of the book is oftentimes, even today, you might look at the decision in West Coast Hotel versus Parish and say, well, that's wonderful. It clearly impacted what FDR was able to do in terms of federal labor laws at the end of the 1930s and early 1940s. What I try to say is that's all well and good, but it misses the bigger picture, which is that the initiative for minimum wage laws came from, and still today comes from, the state level. That's where it resides. It always has resided, and I think the state should be proud of that. Even if there's significant disparity in minimum wage laws, it's always been a state-driven aspect of American policy. And so what I do is to show the impact of the Parish case in Washington state. There's basically an entire chapter devoted to that, particularly to the hundreds of women in King County who were inspired, I think inspired is the best word, inspired by the decision in Elsie's case to bring their own minimum wage lawsuits. There was a flood of them almost immediately after the US Supreme Court's decision. For real technical legal reasons that I get into in the book, many of those women didn't win. But I think rather than focus on that, the important thing is to focus on the fact that they brought their lawsuits in the first place, regardless of whether they won or lost. They wouldn't have done that without Elsie Parrish.
Yeah, and I will say, tell the audience that some of those details that Helen didn't go into involve things like statute of limitations. So it was hard for the women to file that they were being underpaid while they were still working because they were afraid of getting fired. And if they waited to file them until they had left that employer, then they were hitting this statute of limitations problem. But Helen, is it? I'm curious because I don't think I've asked you this. But so scholars have said that this realignment of the court when Roberts switches over to the liberal side then kind of opens the door for much of FDR's New Deal legislation, like this, like Social Security. So that part is accurate, correct?
Correct. Yes.
Okay, and then there's a really, back to kind of where we started, a real interesting part of the story is that so Elsie is this central figure in what people, including Helen, have called this monumental case. And yet almost nothing is known about her, and almost nothing is learned about her by the media. They just seem to go right past her for some reason. And I think I'm going to jump a little bit ahead. I think the best evidence of how obscure she remained is that Oregon's first woman governor, Barbara Roberts, is a grandniece of Elsie Parrish.
Yep.
She did not know about Elsie's legacy. This is the first female governor of Oregon until Helen Knowles calls her to tell her about this. It was a phone call, I'm guessing.
Oh, I actually wrote to Governor Brown's office and asked if they could maybe forward my letter to former Governor Roberts, not expecting that it would get anywhere. And then out of the blue, I shall remember it till the day I die, I was in a hotel room at a conference in Florida that wasn't going very well, and I see an Oregon area code pull up on my phone, and I immediately get worried because my mother lives in Oregon and it wasn't a number I recognized. So I thought, oh gosh, what's gone wrong? And I answer the phone and she says, "Hi, this is Barbara Roberts." And I'm thinking, and then the light goes on and I realize who Barbara Roberts is and I almost dropped the phone. But then, to cut a long story short, I get to go and interview her in Portland, and it was just, I'm not sure who was more surprised about her lack of knowledge of her famous relative, me or her.
And what did she tell you? Like, what was her thinking about how she had not managed to hear this story?
Growing up, it was just sort of vague recollection that Elsie and Ernie were her relatives. And that was it. She had no clue that Elsie had been involved in this monumental legal decision.
And she's not the only family member. She's just probably the most famous of the family members who did not know this. So, as you detail, Elsie then you pick up the trail, and she goes to work in Omak, Washington, and then over in the west side of the state, and then you follow her trail to Southern California. And tell us about how Elsie kind of lived out her years there.
Well, what I have to say that everything I'm about to tell you about Elsie's life down there has been extraordinarily impacted by my great good fortune to have interviewed and become really good friends with Elsie's great granddaughter, Deb Parrish Stewart, wonderful woman.
Yes.
Who's given me the most amazing amount of family photographs, some of which are going to be in the book. And Deb has been an invaluable source because Deb lived for many years as a teenager with Elsie and Ernie. And one of the things she first told me was that as soon as Elsie got married to Ernie, life became a whole lot easier for her because she had a breadwinner. And so Elsie could really take a step back from being a hard-working woman, particularly once they moved down to Southern California. That was really when they moved to Anaheim, that was for them was the ability to, certainly for Elsie to be retired, and then Ernest on his way to retirement. He worked at Knott's Berry Farm.
Yeah.
And Deb tells some wonderful stories to me of the pet turtle that she got, courtesy of Knott's Berry Farm. And so, it's just a classic retired life in Anaheim, just about a block from the gates of Disneyland.
Wow.
Very different Anaheim in the 1950s and 1960s than today. Elsie was a huge diehard LA Dodgers fan.
Oh.
And Deb tells me it's the only time she ever heard Elsie swear when Elsie was watching the Dodgers or listening to Vin Scully's broadcast of the Dodgers.
Wow, that's terrific. And then Elsie passes there. There's I'm trying to remember. There's an interesting story about the day she passed, right? Or
oh yes, one of her, gosh, I would have to double check this. One of her grandchildren had just given birth, I think maybe 2 or 3 days before, and then April 3rd, 1980, Elsie passes away in her sleep.
And still without kind of the just desserts she deserved until Helen Knowles picks up the trail. And I just think that this is the story to me of Elsie and how she came up so hard, and growing up in the windswept. Her older brother dies in a swimming hole accident. It's cramps or something and drowns, and then they move off to Montana in hopes of making it there, and and then just trekking across the West, and enduring the Depression, and then fighting this battle. My point is, I just think it's, to me, it sounds like a movie, and I don't know if anybody's ever suggested that they think it would be, but it leads me to, of course, I want to ask you about what your favorite, because Helen, among other things, has taught a course in politics and film, and I just was wondering what your favorite courtroom drama films were. I asked this of Justice Gary Alexander, who you know, and he's a film buff, and we had a lot of fun with it. So I'm going to ask you as well.
Yeah, it's a fun question, and not only have I taught film and politics on quite a regular basis, I've co-authored one book about law and film, and I have another under contract. So it's a really intriguing question. I have to say, however, that because of what I teach, I very rarely teach courtroom dramas or movies about courtroom dramas. But I was giving some thought to your question, and without a shadow of a doubt, my favorite courtroom drama, even though I never teach it, is My Cousin Vinny. I think it's a terrific film for guiding students through legal procedure. But a close second now, given I'm writing a book, co-authoring a book with a couple of my colleagues about freedom of the press movies. And so now I think a close second for my favorite courtroom drama is a film from just a few years ago called Denial, which is about a British courtroom drama, a real life battle that took place involving a libel suit and a Holocaust denier. It's a truly powerful film. And although it's about British legal procedure, I mean, it has global appeal. So I would suggest that as a really good modern courtroom drama.
Good. And so, Helen, I would be, of course, remiss if I didn't ask when your book, which is being published by University of Oklahoma Press, is going to be out, and how can our audience find it and read it?
publication dates and everything in the publishing industry, like everything in our lives at the moment, is affected by the pandemic. So all I can tell you is what the publisher has told me, which is their best guess at the moment is it's scheduled to be published August 5th.
Oh,
which,
okay.
and I literally only just found out that news. I think, if I recall correctly, that's a day away from the anniversary of the opening of the Cascadian Hotel in 1929. I think the hotel was opened on August 6th, so that would be very appropriate publication date. It's being published by the University of Oklahoma Press, and so it'll be available in all good bookstores and all online places.
Well, I hope somehow it will bring you back out here, and we'll find a reason to chat some more. I also want to mention that Helen was a real friend of Legacy Washington, super helpful to us in our research, and in the acknowledgments of her book, she thanks many Washington State librarians and archivists, many. So people might want to check that out as well. I think that's it, Helen, unless you've got anything to add. It's been so great to have you and to talk about Elsie Parrish, this great but kind of ordinary Washingtonian. And I guess the last thing I would add is that I'm looking forward to reading the book because Helen has things in there from family members that she was not able to disclose until publication. So I'm really looking forward to those hidden treasures as well. So again, thanks, Helen. And if I give the final word to you.
Well, I would say that the thank you definitely goes the other direction as well. You and your colleagues at the State Archives and many archivists at other organizations and institutions across Washington State, the Pacific Northwest, and across the country have been incredibly helpful. And us academics can't do our job without you archivists. So the thank you goes both ways. Thank you very much.
Thanks, Helen. All right. Well, hopefully we'll talk again, and thank you again. Be well.
Thank you.